Perfect. Thank you very much. So I just, first of all, as a government employee, need to give you my disclaimer that's also there on that first slide, that the views I'm expressing today in this presentation are my own views. They do not represent the views or the policy of the US government or of any US government department, whether it's Air Force, Space Force, or otherwise. There we go. So what we're going to talk about today is the due regard principle in international space law. And the key questions that we are going to try to answer throughout the course of this presentation, or that I'm going to try to answer for you throughout the course of this presentation, is to give you the context of why it matters, why talk about the due regard principle now, where it comes from, how we define it and how we use it, how it's been implemented in the past, how we factor into that hard law versus soft law discussion that is ongoing now with regard to the norms of responsible behavior in space discussion, and why it is the prime directive in my view. So bottom line up front, due regard principle is a tremendous tool for setting both general and specific expectations about behavior for the space domain. So if we properly implement it, if states are willing to use it, right, are willing to pick up that tool out of their toolbox and go ahead and use that, then we have opportunities to have a legal regime that is adaptive to different technologies and uses, to assess behavior of states to determine if it is responsible and if it is in line with the Outer Space Treaty on a case-by-case basis, to diplomatically engage and try to reduce the risk that we have misperceptions and dangerous miscalculations among space powers that could lead to destructive escalation, protect our investments in outer space from a commercial perspective, and therefore also encourage the development of further space science by space agencies and others, and generally develop space in a safer, more sustainable, and more secure, or at least really less insecure manner, right? That's a glass half full, glass half empty. More security in many cases really just is less insecurity. I understand that what I'm offering you here today from the due regard principle sounds a whole lot like a TV ad. It slices, it dices, and there's more. But I intend to prove to you today why the due regard principle can in fact be that useful, even though it has not been called upon to its full extent up to this point. So why does it matter? There's been significant discussion about the need for norms of responsible behavior for space. I know in the title it says in space. That's just because I didn't want to use for twice in the title. It's really norms of responsible behavior for space, because the norms of behavior should apply to any behavior that has an impact on activities in the space domain. So in, from, and through space. So for space rather than just consistently in space, as I know Major Gruner has a particular point that he makes on that as well. So some examples of where we have seen the attention on norms for space. So relevant to this audience, the Secretary of Defense issued tenets of responsible behavior for space that we'll talk about a little bit later in the presentation as that relates to the due regard principle. If you look at the interim strategic guidance from the US administration currently, you see there's an emphasis on norms of behavior, not just for space, but also for cyberspace there. And the UN Conference on Disarmament had a resolution that was submitted at the end of 2020 by the UK and Japan that called for states to submit information regarding their understanding of threats in space and how to develop and implement norms of responsible behavior for space. And we had responses from states that have been compiled by the UN Secretary General. Those are available on the UN website if you're interested in reading any of those documents. But there's been significant focus both at the international and domestic level on how we develop norms of behavior for space in order to make the use of space safer and more sustainable, and by default from there to encourage further development and participation in space, whether that's public or private. Overall, we need to find a balance that promotes that development and innovation, as well as free use of space, that freedom of action for states, but without infringing on the rights of others to also develop, innovate, and use space. So what we're really trying to do is maximize our utility in space, where states are able to have secure investments, secure assets, and carry out their activities without preventing other states from using their own rights in space as well to the maximum extent possible. Okay, so quickly, just to give everyone that reminder context of where international law comes from. So if you look at the ICJ statute, Article 38, paragraph 1, paragraphs A through C tell you what the sources of law are that are binding sources of law on states. So international conventions or treaties is the first one that's binding on any states that are party to that treaty. International custom, which crystallizes as a result of the combination of consistent state practice, as well as evidence that states believe they're bound, known as opinio juris. And then general principles of law, so harmonization of laws across legal systems to represent that states have accepted the same principle, right? In all three cases, states have accepted consented to these rules of law, and they are all binding rules of law. That's going to be relevant in our hard law versus soft law discussion. So the Outer Space Treaty is, of course, a binding convention, a binding treaty on those parties who have ratified it, which are a significant number of states. All of the spacefaring states that you think of are all part of the Outer Space Treaty. So we've got Article 9 here that brings us to the core of our discussion today, which is the due regard principle. So I've given you an excerpt from Article 9 and then a summary in the bullets below of the other parts of Article 9, because it is quite a wall of text when you look at it directly. But Article 9 tells us that in their exploration and use of states, in the exploration and use of space, states are guided by the principle of cooperation and mutual assistance, but that they shall conduct all their activities in space with due regard to the corresponding interests of all other states parties to the treaty. So the language that's really important for us here is that shall conduct their activities with due regard to the corresponding interests of all other states party to the treaty. That is the due regard principle. That's what we're unpacking here today. Other important provisions that are built into Article 9 are the avoidance of contamination. So both forward and back contamination. We don't want to bring bacteria from Earth and contaminate other celestial bodies. That's forward contamination. We don't want to bring stuff from space that could contaminate Earth and be dangerous to Earth. That's back contamination. And then the part that's more relevant to the due regard principle is the consultation provision that says states have to consult in cases where they believe they might cause potentially harmful interference to other state space activities, or states who think that their activities might be harmfully interfered with can also request those consultations. So it's an obligation to consult, it's an obligation to discuss with the other state to try to overcome that harmful interference. Now, two important things I want to point out here. One is it's harmful interference. It's not just any interference. So not all interference is harmful. It has to rise to the level of harmful interference. And then secondly, as you can see from this provision, there is not a total prohibition on harmful interference. There is merely a requirement for consultation, which inherently would be carried out in in good faith, in accordance with rules of international law, but does not require total resolution of that harmful interference. So there is space here within Article 9 that harmful interference could occur and be permissible under the Outer Space Treaty if the appropriate steps have been taken, if the activity was carried out with due regard, and their consultation was carried out if that was requested or if it was apparent that there might be harmful interference at play. Okay, so in terms of interpreting the due regard principle, we have to apply pacta sunt servanda. What that means is that's a principle that has been articulated in the Vienna Convention on the Law of Treaties. And what that really means is that states have to carry out their treaty obligations with good faith. They act in good faith when they take on treaty provisions. They're not going into it thinking, how can I manipulate this? How can I get around complying with the spirit of this treaty? You're going to go into the treaty acting in good faith. In accordance with Article 31 of the Vienna Convention on the Law of Treaties, which has articulated a customary international law set of rules for treaty interpretation, you start when you're trying to interpret a treaty provision by using its ordinary meaning. Now, ordinary meaning in this context is its ordinary meaning in international law, not necessarily its ordinary meaning in terms of the person on the street. It's a specific ordinary meaning. So we interpret ordinary meaning in order to understand what the ordinary meaning of the term is. which is why I gave you the Inception meme here on this slide, because it is a bit of a layered approach. And we also get to look to the context of the Outer Space Treaty. Particularly relevant to us here is the preamble to the Outer Space Treaty, because the preamble clearly demonstrates a desire to encourage the development of peaceful uses of space, exploration of space, right? The Outer Space Treaty wants states engaging in more of these activities and developing more of these activities. So we should look at the treaty as an effort to help those activities develop while maintaining peace and security in the space domain to the greatest extent possible, in line with the UN Charter and the articulated terms in the preamble. So with that in mind, when we start our analysis of the due regard principle, we see that in a general dictionary definition, Merriam-Webster, due regard means with proper care or concern for, right? And then in Black's Law Dictionary, specifically in a legal context, although specific to common law jurisdictions rather than international law, but still a helpful guide when we're thinking about what might this rule mean, to give fair consideration to and give sufficient attention to all of the facts. And so when you see in these cases, it's proper care or concern, it's fair consideration, it's sufficient attention. It is not total care, right? It is not total attention. It is not excluding all other considerations. It's a fair consideration for those interests of other states in conducting their space activities. It is also tied to the interests of states, which are evidenced by their space activities that they're undertaking and their communications regarding their space activities and proposed space activities. So from the perspective where we're often trying to interpret the intent of states as they're carrying out those activities, the intent of states is not something that we have to get to in order to understand what due regard is. We need to understand what their interest is in terms of what are the activities that they are planning or would like to be able to carry out someday. Those activities are the interests of that state in space. How do we accommodate those to the greatest extent possible within the law, right? And without unduly infringing on our own access and use, our own freedom of action in space. To look at the flip side of due regard, the flip side of due regard is disregard, which one of the scholars who has written extensively on this in an international environmental law context has defined it as disregard evinces disrespect. Due regard promises respect, tempered by the reality that respect for all inevitably involves trade-offs and judgments. So again, what we're looking for here is that balancing test, that balance between the interests of states in order to get due regard. Therefore, we are acting without disregard, but not acting with total regard. It's due regard, not total regard. So in the third paragraph of Article 31 of the BCLT, we just talked a little bit about the first two paragraphs in the context of treaty interpretation. I've given you the text here as to how we might use norms of behavior to interpret what due regard means in different ways as we move forward. So any subsequent agreement between the parties regarding the interpretation of the treaty or application is going to be applicable in a treaty interpretation context. So this is not capital A agreement. It does not say treaty. It does not say convention. Therefore, we can have a broader interpretation of what an agreement between states might constitute. So some scholars would argue that UN resolutions adopted by consensus, like those that come out of the UN COPUOS, might provide evidence of a subsequent agreement between the parties regarding interpretation if they are written in a way that is clear, that demonstrates an intent to tie back to the provision of that treaty and implement the provision of that treaty. In paragraph B, you can see subsequent practice in the application of the treaty is also relevant. So we look at how those states that are party to the treaty have implemented that treaty, how they're behaving in space. And if their behavior is consistent, there's conformity in that practice, then we know that behavior is something that is in line with the treaty, that conforms with the treaty, as long as other states are not calling out that behavior as a violation of that treaty provision or as something that might be considered wrongful under that treaty provision. So you look at the activities, but also the practice in terms of the communications about the treaty and whether or not other states' behaviors are compliant with the treaty to determine the parameters, the interpretation of that provision. So we can use due regard where we see it in those subsequent agreements to tie back to Article 9. So we could frame subsequent agreements as implementations of due regard, either in general or for a specific activity, if we had an agreement regarding a specific activity. So for example, there are existing remote sensing principles. There's a resolution on that that has come out of UN COPUOS. But if in the future there was to be subsequent agreement, say on the use of safety zones on orbit or on a celestial body or on space resource utilization, that's the kind of subsequent agreement that you could specifically articulate what due regard looks like in the context of that type of activity. And then subsequent practice, it's important to see what states consider acting with due regard versus acting with disregard. And if states are willing to utilize that language when they're talking about their own space activities and the space activities of other states that might endanger safe operation in the space domain, then that's going to strengthen the application of that rule, that due regard rule from the Outer Space Treaty. Okay. So let's talk here for a minute about hard law, soft law, and whether or not there's an intermediary option that might be available. So when we talk about hard and soft law, usually what people are thinking about is it a binding rule or is it not a binding rule? If it's a binding rule, it's hard law. If it's not binding, if it's just a guideline and there's not a requirement that states comply with it, then it's soft law, which really isn't law, but more like a guide for behavior, standard practices for behavior in space, until and unless it became part of the law, either through a treaty or by crystallization into customary international law. So we're really talking about the form that a treaty comes in, or excuse me, the form that a law comes in to determine whether it's hard law, right? A treaty is hard law, something that is just a resolution or a set of guidelines adopted. That's soft law, that's non-binding. But when you're looking at legal provisions to determine how you apply them, it's not just the form, it's not just whether it comes in a binding form or not, but also the substance, what is articulated within the context of that binding document or binding set of rules. So the substance is what establishes an obligation, how clear that obligation is, right? What the parameters of that obligation are, and whether or not there's any enforcement available specifically with regard to that provision or those provisions. So importantly, think about the fact that the terms soft, vague, and aspirational are not all the same. Usually if we're talking about something that's soft law, you're saying it's coming from a non-binding source. But you can have vague language that is in a treaty, that is in a binding source, and that is still a binding rule that is vague in terms of how we apply it as written in the treaty, but it's still binding. And then aspirational, you can have language in even a binding treaty that is written in such a way that it is not intended to be creating a rule in and of itself that states are going to follow as a hard rule, even though it's within a binding document. So the reason I pointed out when we were talking about Article 9 that states are guided by the principles of mutual assistance and cooperation, right? It says they're guided. That's not language that implies a direct obligation to assist or to cooperate, but to be guided by that principle. Think about that principle as you're carrying out your activities. It's not a hard requirement to cooperate. By contrast, where you see the language for the due regard principle, states shall act with due regard to other states' interests in space. That's shall language. That is not aspirational, right? Guided by, that's more aspirational language. Shall act with due regard, that's not aspirational. So even though the words due regard may be somewhat vague and may not articulate a very clear rule in and of itself as a phrase, it's not just aspirational and it's not soft. It is a binding rule for states that are party to the Outer Space Treaty. And it's also binding if that's considered to be part of the customary international law that has crystallized from the Outer Space Treaty. Or from the Principles Declaration that predated the Outer Space Treaty. So we can do a case-by-case assessment of behavior based on that binding law in Article 9 to determine whether a particular activity or a particular behavior is a behavior that conforms with the due regard principle. Did you act with due regard for other states' activities when you decided to carry out this activity? How much did you communicate in advance about what you were going to do, depending on what kind of an activity it is, right? Those are factors that we can take into account as we're doing that case-by-case assessment. So we can have non-treaty agreements like resolutions that I just mentioned that can serve as that intermediary option between traditional concepts of hard and soft law by tying specifically in this case through Article 9 of the Outer Space Treaty. So while the resolution itself would not be a binding document, would not be hard law, it would be considered soft law in terms of form. If it ties specifically to Article 9 of the Outer Space Treaty and it's adopted by consensus, then it has more teeth. It has more weight to help us get to binding rules, to help us access Article 9 of the Outer Space Treaty, to implement that rather than just having this nebulous set of guidelines that states may or may not choose to abide by. Keep in mind also that under the paragraph of Article 38, paragraph 1 of the ICJ statute that we have not talked about because it's not binding law in and of itself, but it's still relevant here, decisions of courts and tribunals, as well as the writings of the most highly qualified publicists, are considered subsidiary sources of international law. So they're not dispositive, they don't create a binding rule of international law, but they're persuasive and they can help you figure out either if a rule has crystallized into customary international law yet, or how we interpret and apply a treaty provision that exists. And so we can use those sources in that subsidiary means moving forward. I also want to mention that analogous applications of rules of international law from other contexts, from other domains can be helpful, right? They can be persuasive, but they're not going to directly transfer. And it would be very dangerous to just directly transfer principles from other domains because they have different legal systems. They are different operating, from a physics perspective, different operating domains. It does not make sense to just port over rules, even though the high seas, for example, might be a very similar context to outer space. It's not exactly the same. So we can't just port rules from the high seas to space, but we can use the interpretation and application of similar rules from the high seas and analogous domains to help understand what the obligations are in space where it makes sense to do so. So in international law, we have due regard that shows up in a variety of contexts. So in maritime law, we have due regard. If you look specifically at the UN Convention on the Law of the Sea, it codifies due regard in a couple of different ways. The one that's most relevant to us is due regard on the high seas, because that is an area beyond territorial jurisdiction. So there is also a rule, for example, that states operating in an exclusive economic zone in maritime law have to act with due regard for the rules that the state with the EEZ has put in place. That's less relevant in space as a rule, because certainly we do not have exclusive economic zones in space. But if we see what due regard looks like and how due regard is implemented, that's still helpful because that terminology is still the same. The standard of due regard is still the same, even if it is being applied to a different set of rules in a different context. So we do have multiple avenues of due regard in maritime law. So when you hear due regard in maritime, don't automatically assume that it's only the due regard principle on the high seas, though that is the one that is the most comparable to space. We also have the due regard principle in international environmental law as well. And there are scholars who have written about it in that context to help us get to the understanding of what due regard means and how we might be able to apply that in general. And then I'll also mention, because this is particularly relevant to the military audience that many of you fall into here, that in air law, there is a rule in the Chicago Convention on Civil Aviation that says state aircraft, which includes military, postal service, Coast Guard, etc., have to act with due regard for civil aviation. So civil aviation and commercial aviation is acting under a specific set of rules that have been put in place by the states cooperating in the International Civil Aviation Organization, which is a UN body. That civil aviation, that commercial aviation does have to follow all of those rules specifically, But state aircraft, including your military aircraft, don't have to follow those rules specifically, but they do have to act with due regard for civil aviation, understanding that those other types of aviation are following these specific ICAO rules. You know what the ICAO rules are, you have access to those rules, so you know what those civil and commercial aircraft are going to do, and so you need to act with due regard for those activities. So we have it in that context as well. So due regard is not unique to space. It is not a brand new concept. It's something that's been significantly applied in other areas of international law. So in space law, we have it codified in the Outer Space Treaty, which we already talked about. There is also the discussion of whether it has developed in space as a customary principle, either predating the Outer Space Treaty, coming from that principles declaration that I mentioned, which does include the due regard principle in its language, or in parallel with the OST after the OST has been adopted and more states have been acting in space. Personally, I would argue that yes, this principle is part of the customary law package. Certainly not all of the Outer Space Treaty is considered customary, but that the due regard principle would be part of that package. And that is as a result of the fact that it's really the thread that ties the Outer Space Treaty together. And we'll talk about that toward the end of the presentation, how it is the prime directive for international space law. And then finally, we can look to the due regard principle as it may exist in general international law beyond the bounds of maritime and environmental law, if there's a general duty of due regard in the interactions between states and whether that would be applicable to space. So we have different places that we could access the due regard principle. Here we are really primarily focused on the Outer Space Treaty directly, but I wanted to mention these other avenues for awareness as it is relevant to the overall discussion. So the best articulation of the due regard principle and how we interpret it that I have seen came from the decision in the Chagos Marine Protected Area arbitration from the Permanent Court of Arbitration in 2015, so relatively recent, modern quote here. And as we talked about, this isn't going to create a binding rule. We don't have to use this in interpreting what due regard means, but it's persuasive, right? It comes from one of those tribunals, as mentioned in Article 38(1)(d) of the ICJ statute. And so we can use it as persuasive in how we're going to apply this principle. Understanding that what we're interpreting here is the UN Convention on the Law of the Sea, not the Outer Space Treaty, but the language of due regard is the same. So we have to take all of that into account when we're thinking about how we might apply this in a space context and whether it's relevant. So the quote says, the ordinary meaning of due regard, again, ordinary meaning ties back to those rules of treaty interpretation, calls for the state party to have such regard for the rights of another state party as is called for by the circumstances and by the nature of those rights. The tribunal declines to find in this formulation any universal rule of conduct. So to unpack what that means, first of all, you take it on a case-by-case basis. You look at what else is going on. What is the state trying to do? What are the activities of the other state or states that might be interfered with, that you might be acting with disregard for in that circumstance? How do you balance those? You also look at the different contexts of the activities. There's no universal rule. So you might have a different rule for what due regard looks like on orbit versus on the surface of a celestial body. And that's okay, even though it's an identical rule within the Outer Space Treaty. It doesn't differentiate between applying it in one location versus another. You can still apply it using that principle, right, of balancing between the interests between states. So if you're talking about what safety zones might look like, that was an example I gave before, that's somewhere where this is highly relevant. What operations on the lunar surface might look like, different types of activities. If you're talking about on-orbit servicing, how do we conduct on-orbit servicing or active debris removal with due regard? There might be specific ways that we can demonstrate we're acting with due regard in those contexts that are not applicable to all space activities. So you can have those different regimes and you can have a case-by-case analysis just on an individual action or individual behavior. So as I stated previously, when we were talking through what due regard means, it's not total or maximum regard. Some interference, even some harmful interference, could occur in the context of due regard, but the primary purpose is to eliminate unjustified disregard. Right? There's such a thing as justified disregard. If you've had a consultation, you've tried to resolve the problem, you can't resolve the problem, but your activity is extremely important to the interests of your state, then it is justified in some circumstances to disregard the activity of the other state. But you have to do that case-by-case analysis. You have to do that balancing test for due regard. And there has to be good faith. So going back to pacta sunt servanda, right? You take on your treaty obligations and you carry out your treaty obligations in good faith. So the consultation isn't just, hey, I was willing to talk to you, I said 3 words to you, therefore we have consulted, but it needs to be evidence of an effort to provide regard, right? A good faith effort to act with regard for the other state, even if you ultimately cannot respect their activity, or you ultimately have to interfere with their activity in a context, even if that's harmful. So it's optimal regard. It's an optimization strategy. How do we maximize everybody's freedom of access and use in space while minimizing, not eliminating, but minimizing the disruption or the interference to other states' activities? Okay, so I've got a bit of a stoplight chart here for you, because we know that the military services love stoplight charts. So we have subsequent practice of due regard. These are just some examples. These are not all that exist out there, but there's some helpful ways to talk about how due regard has worked in the past. So the ones I've put in green are the ones that I think are helpful, right? These are ways that we've used due regard that is helpful to the development and application of that principle. In red is where I see some problems where states are ignoring or not optimally using the principle as a tool in their toolbox. And then the yellow one, and particularly on the SecDef tenets of responsible behavior, has some positive and negative aspects to it in terms of implementation, and we'll talk through that when we get there. So the NASA recommendations to spacefaring entities are about preserving the artifacts that were left behind on the moon from the Apollo missions. These were issued in 2011, and they set parameters for what kinds of activities might cause damage to the equipment that was left behind on the moon. So how close you can land, depending on what kind of lander you're using, without kicking up a huge amount of regolith that's going to cause damage in that burst to the equipment that is already there. Most of it is written from a very scientific perspective in terms of, okay, based on the information we know, which is limited information, here's how we think that this would apply with different activities. But what these recommendations that NASA is asking for are supposed to do is comply with the Outer Space Treaty first and foremost. And in particular, the document says that nations are guided by the principle of cooperation and mutual assistance, again, that guided language, the aspirational language, in lunar exploration and use, which is the context of this document, and with due regard to the corresponding interests of other states parties to the treaty. So they do incorporate that Article 9, they do incorporate that due regard language specifically into the recommendations as they are articulating what they think might cause harmful interference with their activities. So they're flagging, hey, if you follow these recommendations, you're not going to harmfully interfere with us. If you don't, you might. So here's an opportunity to be transparent and have an opportunity for you to see that you might need to consult, right, at the end of the day. In terms of ASAT tests, you see that chart there from Secure World Foundation in 2022 regarding ASAT tests. The ones that I really want to focus on are, first of all, the Chinese ASAT test that took place in 2007. As you can see from the column there, the number of pieces of debris created, the debris that is still in orbit, and the length that we expect to see the debris remain in orbit is far and away the highest of any of those ASAT tests that has been conducted. One of the 2 most debris creating events that we've seen in space, and therefore creating a hazard for others operating in the same orbits. So in the case of that 2007 ASAT test, we did not see states using due regard or disregard language in order to call out that test. Yes, states articulated that it was dangerous, and but not in the context, in the terms of the Outer Space Treaty Article 9. Now, that was the first ASAT test that really caused significant debris. If you look at those debris numbers, particularly in the context of how much was going on in terms of overall space operations at the time. And so maybe there's a learning curve, right? You say, okay, well, maybe states didn't react quickly enough to think about how they could use that treaty language. And so therefore, maybe we just didn't get there for 2007. And I was hopeful when we got to that Russian test in 2021, you see it's the bottom line there, that creates a significant amount of debris, but not the same as the Chinese test, still less than that, but still far more significant than the other tests we've seen, that we would have gotten to a point and been ready for that in 2021 to be able to use that due regard or disregard language to tie that to the treaty and use the teeth of that binding obligation when we're talking about the actions of a state in space. Unfortunately, that mostly didn't happen, right? Most of the statements that came out with regard even to that Russian ASAT test at the end of 2021 did not use due regard or disregard language. I did pull the two examples that did use it that I found and put them here on this slide. Interestingly, they're both in a defense context, right? They're not the foreign ministries of the countries involved or the heads of state of the countries involved or heads of government that are using that language, right? While State Department did come out and say that the test was dangerous, right, was irresponsible, they didn't use that due regard, disregard language. However, General Dickinson did for the commander of US Spacecom, right? Deliberate disregard was the term that he used. And also the Ministry of Defense, Minister of Defense in the UK, Defense Secretary, came out and said, this is a complete disregard, right? So clearly deliberate disregard and complete disregard are in that context of due regard. They evince behavior that is not due regard. Neither complete nor deliberate disregard would evince due regard. So that's helpful, right? So if we think in this context, if we have more representatives of the states actually coming out and saying this behavior is acting without due regard or is acting with disregard, then that's helpful. That helps develop that state practice to apply due regard from the Outer Space Treaty to the activities of states, and helps us continue to develop and evolve that interpretation of the due regard principle. I will briefly mention the Indian ASAT test that took place in 2019 that you see on that list. So India, while they did create some debris, in their statement, they articulated that they were really trying to minimize that debris, felt they needed to conduct that test to demonstrate their capabilities because of their unique geopolitical situation. And so while there were a couple of states that said, hey, this is debris creation, this is unsafe, this is jeopardizing commercial and civil operations, the outcry from that test was significantly less than from the Russian test. Understandably so, even if you just compare those debris numbers as they're listed on that chart there, you can see that that is not an apples to apples comparison for anti-satellite testing. So the Artemis Accords is an example where we have seen due regard being normalized and being used. The Artemis Accords are not a binding treaty, and they are not having any effect on states that are not party to them. So the United States has initiated the Artemis Accords and has had a number of other states sign on to those accords, particularly looking forward to lunar and cislunar activities. In particular, from Section 11 of the Artemis Accords, we see here, we're calling out the provisions relating to due regard and harmful interference in the Outer Space Treaty, affirming that commitment, recognizing that it is a commitment, right, and reaffirming it. And then stating that consistent with that article, that any signatory to the accords would commit to respect the principle of due regard, right? Bringing that back up to the forefront, highlighting it, making it important, and that the signatories would commit to seek to refrain from intentional actions creating harmful interference with each other's use of outer space. So really highlighting and trying to develop state practice under the Outer Space Treaty. So those states that are part of the Artemis Accords, right, their practice is providing evidence of how they see the use of these principles moving forward. Section 11 also addresses safety zones and harmful interference with regard to safety zones. I put it here just because I know that's one of the key areas that are being looked at for norms of responsible behavior in space, and showing that we're trying to normalize in our state practice as you know, the members of the Artemis Accords, that these safety zones may be necessary and can be conducted in accordance with international law and are specifically used to avoid harmful interference. Okay, so that SecDef memo from 2021, tenets of responsible behavior in space. I've got a quote here from the memo with the specific tenets bulleted there. The one, of course, that we are focused on here is that first bullet that says operate in, from, to, and through space with due regard to others. And the SecDef has added in a professional manner to that language and in a professional manner. So other scholars, I don't know if John Goring is on listening with us today, but he has some published articles out there, and one of them addresses this particular problem and how this can be harmful to the due regard principle, because by pulling it in and saying, unless otherwise directed, the DoD is going to follow along with this tenet, then we're diminishing its usefulness by saying there's a possibility that the DoD components might be directed to do otherwise, right? Might be directed to not act with due regard. I think there is a reasonable interpretation, additionally, a different reasonable interpretation that looks at this and says, we're highlighting due regard because we think it's important and we want to use those words because we think they're important words. But what we're adding here is, and in a professional manner, and that in a professional manner is the part that is more considered to be that waivable, right? Otherwise directed part of that first tenet, but we want to use that due regard language to highlight that language because it is important as we're continuing to develop these norms of responsible behavior. And certainly both of those interpretations as to whether it could be useful or whether it's just detrimental, I think are reasonable interpretations, giving you some different perspectives on this document. China and Starlink is another interesting example. So in December of 2021, the PRC furnished information to the UN Secretary General stating that there was a phenomena that was dangerous to the life or health of astronauts aboard their space station, aboard the Tiangong. And so in doing so, they called on Article 5 of the Outer Space Treaty that says, and they quoted it in their submission to the Secretary General, that states will inform the SecGen or other states parties if there is something that they discover in space, a phenomena they discover in space that could constitute danger to life or health of astronauts. And so they filed saying, hey, we think Starlink is a danger to the life and or health of our astronauts. There were twice that we had to do collision avoidance maneuvers because of Starlink assets in 2021. And so what's really notable about this is that provision, that Article 5 on its face, we might assume is really about naturally occurring phenomena in space, right? Whether that's asteroids or natural debris or solar radiation, right? Bacteria that might exist in space, forms of life in space that may be threatening. China here has brought that principle to use in a man-made context. And they used this instead of the Article 9 due regard principle. They didn't call for consultations with the United States. They didn't make a statement saying the United States through Starlink is acting with disregard or is not acting with due regard. They didn't use Article 9, they used Article 5 instead. And so some would argue, okay, this is weakening Article 9. It's showing that Article 9 is not something that states are having respect for in their practice, which may well be true. And I think it is not helpful to Article 9. But I would argue there might be another reason for using Article 5 instead of Article 9. And that's that the only obligation under Article 5 is to provide information, right? So they file this information to the SecGen. It then becomes publicly available on the UN website for anybody to view. But that has ended the obligation of the state filing that paperwork with the SecGen. It does not then draw the state into consultations with the United States as the Starlink provider, which may be something for geopolitical reasons that a state might choose to avoid. And they wouldn't be required to because they're the ones saying they were interfered with. So they have an option to call for consultations, but not a requirement if you look at the language of Article 9. So there might be reasons in that political context why they would choose to use Article 5 rather than Article 9 that does not demonstrate that Article 9 is not useful. Very briefly, expert group, the Hague International Space Resources Governance Working Group, put together some building blocks using international experts over a period of a couple of years to try to articulate how we could carry out space resource activities consistent with the Outer Space Treaty. They did specifically also include references to the due regard principle in developing their framework and have added some activities that they frame how you can implement them with the due regard principle in mind for priority rights, resource rights, and safety zones. So to the extent that states make comments on these, whether at UN COPIOS or elsewhere, or take them on board and implement them domestically, that can show evidence of state practice, but the expert group in and of itself is not providing anything other than this information provided by experts. Okay, so to kind of summarize how the basic rights and duties of the Outer Space Treaty work, we have a universal right to use and explore outer space coming from Article 1. We also have, of course, the prohibition on territorial sovereignty, so we can use and explore, but we can't claim sovereignty, we can't appropriate space. But in our right to use and explore, right, it's not unlimited. We have to act with due regard for other state space activities. It is the main balancing factor in the Outer Space Treaty. We have those specific other prohibitions. You can't claim territorial sovereignty, you can't station weapons of mass destruction in space, celestial bodies are for exclusively peaceful uses, right? We have these provisions and they are definitely binding in the Outer Space Treaty. But in terms of a rule that's going to pull the whole thread of the Outer Space Treaty together, hold it all together, and determine how we're going to conduct our activities, the due regard principle is how we get there, how we maximize the activities that we can carry out as humanity in space, because that universal right to use and explore has a congruent obligation to respect other states' rights to use and explore. If we maximally used our right to use and explore without regard for other states, that would mean that states could see, oh, well, another state has a satellite in this particular orbit. I'm just going to launch my own satellite, gently push it out of orbit, and take the slot that it's in. I'm just using and exploring outer space, right? That's just a use. I'm just using space. Don't mind me. I have a right to use space. So you have to look at what the congruent obligation is that comes with that right. The congruent obligation is really to act with due regard. And of course, you do have to follow all of the other specifically articulated rules required in the Outer Space Treaty. So why are we calling it the Prime Directive? In my view, it is not just a clever name that people will think, oh, I know what the Prime Directive is. I've heard of or seen Star Trek. That's where this comes from, which is true. That's where the concept comes from, right? There's a Prime Directive, general order for the Federation in Star Trek that is non-interference with pre-warp civilizations. It is not the same as what we're talking about here, certainly. But the reason I'm calling forth that Prime Directive language is because it is helpful to understand the kind of rule that due regard is. So some folks call it the golden rule. I would argue that calling the due regard principle the golden rule is not helpful, because the golden rule is an ethical is an ethical rule rather than a legal one, and it's entirely subjective. So treat others as you wish to be treated, right? Entirely subjective. How do I wish to be treated? It may not be the same as somebody else wishes to be treated. The United States may not wish to be treated the same way that another state would wish to be treated. And so that subjective element in that ethical framework is not really articulating how we want to use the due regard principle, which is a binding legal rule with an objective interpretive lens, right? You look at the interest of the state and the activity that they're carrying out, they're carrying out, and you balance that against the other activity that's being carried out and see if we can compatibly undertake both in space, right? There's that objective interpretive lens in international law that's more of a reasonableness standard. It's not, how do I wish to be treated? What do I want to do? That's the most important thing. So back to intent, right? We don't need to understand the intent of the other state. We just need to understand what the activity is that they're trying to achieve, because their interest is in that activity. So it's predicated on autonomy and sovereignty. So as a prime directive, due regard inherently respects the sovereign equality of states as articulated in the UN Charter. And it provides maximum autonomy for states to make their own decisions and to carry out their own programs, maximizing freedom of action while respecting activities and interests of others, right? Maximizing freedom of action is autonomy, respecting activities and interests of others is sovereign equality among all states. And then we can see that disregard is what failure looks like. So under the Outer Space Treaty, if states act with disregard, then the Outer Space Treaty is not going to function. Not all states are going to be able to carry out use and exploration of outer space. So we have to determine how responsible a behavior is, or how responsible a behavior can be, by its impact on other individual states and their activities, and on the impact of the international community of states as a whole, known as an erga omnes obligation. So when we're looking at massive debris creation, for example, it may not be infringing immediately on a particular individual state's interest, but a significant amount of debris creation in a widely used orbit infringes on the rights of other states as a whole to be able to utilize that orbit moving forward. So that's more of an erga omnes obligation. So we have both elements there to the due regard principle. To put it another way, we are managing both negative externalities, right? Those negative actions effects, or sorry, the negative effects that an action may have on a state's particular activity, and also potential inequity. States in the future may not be able to actually use and explore space if we don't act with due regard, if we instead act with disregard. Okay, so recommendations moving forward. Any efforts to articulate either general or specific norms of responsible behavior. So general, right? How do we implement due regard overall? Or specific, how do we manage on-orbit servicing, right? As a specific example. Those norms should expressly state that they are framing standards and expectations in line with the due regard principle. Specifically call out Article 9, specifically call out that language, and make it part of the effort to articulate those norms, whether it is through statements of states, whether it is through recommendations or guidelines coming out of UN bodies or coming out of other expert bodies or other smaller groups of states who are working together in a project, like, for example, in the Artemis Accords. Note that any guidelines are implemented to fulfill the obligation to act with due regard, creating that clear nexus with Article 9. And states also need to call out conduct that does not conform to expectations of due regard. So you need to name and shame disregard. This is how we give teeth back to the due regard principle, back to Article 9. Examples of specific areas that we could develop, I think I've mentioned all of these, but these could have specific rules for how you act with due regard in the context of activities taking place either in these locations or carried out for the purposes listed below. So conclusions, the due regard principle provides us with an adaptive legal system that can be applied in the context of changing technologies, in the context of new actors in space, can be used for civil, commercial, and military operations. It's already binding and thus gives us intermediary solutions between truly soft guidelines and new hard treaties. It can be used to harden specific norms, to add those teeth through subsequent agreement. But states have to be willing to commit to using that tool in their toolbox, to articulate and specify that they're using the tool in that toolbox, because state practice is important. So say that your own activities are conforming, this is how I'm acting with due regard, and say when other states' activities are not conforming and they are not acting with due regard. Thanks very much. I'm happy to take questions.
Great, thank you, ma'am. We do have some questions that have flown into the Q&A. I know that we are approaching 9 o'clock, but ma'am, do you have time for several questions?
Sure.
All right, great. So I'll just start in the order that these have come in, and hopefully we'll be able to hit them all. So I think that maybe this first one you addressed slightly later in your discussion, but Mr. Mark Meyer has asked, how can we find common interpretations and definitions of some of these somewhat inexact law terms kind of that are publicly available, right? So if members of the public wanted to understand what these terms maybe meant, how would they go out and find interpretations and definitions that would be helpful in understanding those terms?
So first of all, I would recommend that folks could look to the available sources that some of the scholars who are studying this have put out there. This, for me, is part of a bigger project that I'm intending to publish. I'm presenting 2 of the pieces of it at the International Astronautical Congress coming up next month in September. And so there is work being done out there that's available if you dig into it and look there. I mentioned John Goring earlier in the presentation. He's got a couple of different pieces at different levels of specificity and availability. One of them's out in the public domain. One of them's, I think, behind a paywall for a law journal article, but those are helpful. Of course, if states were willing to get together and put together an interpretation guide for these terms, right? So if you look at UN COPUOS, there is a resolution that UN COPUOS provided their concepts in applying the term launching state, right? Because launching state's important in the treaty. So we could have a document like that that would evolve, in applying the due regard principle that could provide guidance. I think that would take years. It's not something that UN COPUOS or any other body is working on currently, as far as I'm aware, but that would probably be the most helpful way to get there in terms of publicly available documents. Some of the stuff that I mentioned, like the state responses to the resolution regarding threats in space and norms of responsible behavior, that's all available on the UN website. So the public can access the UN documents and can access from any of those UN meetings the statements that states have made during those meetings as well. So there's a lot of information out there, but there are efforts being made now in the community to work on these terms and to get that information out there to kickstart that discussion, not just within governments or within scholars, but also for the general public as well. But that's a great question. Thank you.
Great. Thank you, ma'am. Our next question comes from an anonymous attendee. Can non-state actors provide context or subsequent practice for the development of soft law? For example, what effect do, quote, guiding principles about best practices, end quote, at an international commercial consortium have on our understanding of harmful interference and due regard?
So that's a great question. And here I'm going to pull us back to Article 6 of the Outer Space Treaty, which is the article that tells us that states have responsibility for all of their national activities in space, even for those private companies. And that means that states are directly responsible for their compliance with international law. The state has to ensure that their actors are complying and that those activities are considered state activities for the intents and purposes of international law. So for example, if Starlink does something that's the United States' behavior as far as the international space law system is concerned because of Article 6 of the Outer Space Treaty. And so I think uniquely in the space domain, not in other domains, but specifically for the space domain, you can look at that behavior that private actors are carrying out and attribute that to the state, right? What Starlink is doing is representative of the United States. So to the extent that those companies are articulating the principles that they're following that can contribute to the overall development of the state practice, of course, as long as that is in conformity with what their government is actually calling out and doing and saying, right? If the government statements don't align with it, then it's not going to be a valuable source. But if it's in conformity compatible with their government statements and activities, then that can be a helpful item on the list, adding to an overall demonstration of state practice.
You mentioned the Indian ASAT test when you were discussing ASAT tests and their kind of contribution to understanding of due regard. We have another anonymous question that asks, can you elaborate on the concept of justified disregard? And for example, how should we weigh India's interest in developing an ASAT weapon with US interest to limit orbital debris? Do you feel that the Indian ASAT test was an example of perhaps justified disregard from the Indian perspective? But really, can you elaborate on that justified disregard concept?
Sure. In my opinion, right, I'm not even sure that the Indian ASAT test rises to the level of disregard, but if it does, I would argue that it does indeed fall into that justified disregard example. So the reason I say that is because if you look at the test itself and also what India has articulated about the test, they made efforts to minimize the amount of debris that was going to be created, trying to bring that down to zero as much as possible within the limits of the technology that they were using and their tests that they were using. So when you're talking about an ASAT test, there are really three main factors that determine how much debris you're going to create and how much of a problem it's going to cause. The velocity at which your ASAT weapon kinetically impacts the target, the altitude at which it impacts, and the angle at which it impacts. So higher velocity, more debris. If the angle is more straight up and down from Earth's surface, more debris that's going to be long lasting because it's kicking it out further and it's going to take longer to deorbit and burn up. And then the angle, again, in terms of where that any potential debris is going to go. If it goes into a higher orbit, stays longer. If it's pushed down, it burns up very quickly and becomes less of a long-term impact. And so India tried to execute their test in a way that would minimize debris. And if you look at those numbers from that Secure World Foundation chart, you'll see they were pretty successful, not as successful as they wanted to be. And there was some debris that could have interfered with the International Space Station, which is not good, right? But they demonstrated an effort to act with due regard. Now, if we take the position that all debris creating ASAT tests inherently involve some level of disregard, then in that case, which is a perfectly reasonable position, right? I would support that interpretation as well. Then I think we can say that India's disregard was justified. They did what they could to minimize the risk, but because of the geopolitical situation that they have articulated that they feel like they're in, right, expressing their interests, it was essential to their interests to carry out this test, and therefore they were able to act with this justified disregard and not violate the Article 9 prohibitions. Certainly no state specifically said that they violated due regard under Article 9, as we talked about. There is not an existing prohibition on ASAT tests, right? Many states have carried them out. The United States has unilaterally declared that we are not going to do them anymore, which is great, right? The United States certainly has the authority to do that, but the United States can't bind other states to that. So in the absence of either a subsequent agreement or state practice, overall, more than just the United States, right? Practice of more states determining that ASAT tests are prohibited either by the due regard principle or by some other principle in the Outer Space Treaty or some future rule that would either be adopted or that would crystallize, then in that context, right, the 2019 context, and that's before the US unilateral declaration even, India's test is, in my view, justified under Article 9.
All right, the next question is an interesting kind of whole of government question. Also from an anonymous attendee. What do you see as the difference between interpretations arising from kind of the defense context, right? DOD and the tenets of responsible behavior that have been articulated, right, by the Secretary, the State Department context, the civil context, and NASA, and the commercial context? Do you see interpretations of due regard in these different and separate contexts as being different, or do you feel that they are kind of working together towards the same sorts of understanding of the principle?
So I think there's potentially two different questions embedded here, right? One would be, how do we interpret and apply? Does it matter which context you're in, whether it's defense, whether it's civil, whether it's commercial? And I would argue that the principle can be applied regardless across all three contexts, though there might be different ways that you would apply due regard. That's on that case-by-case basis, right? Looking at what is the interest of the state. So if you're talking about something that is a really significant national security interest, really significant concern, a missile warning, for example, then it would take less interference or less disregard to be considered acting with disregard if you're interfering with something like that versus a different type of interest, different type of activity in space, right? You can apply that in a case-by-case context, but it could and should apply equally across all of those different contexts, largely because in space, you can use the same asset for a civil purpose, for a commercial purpose, and for a defense purpose, depending on the particular mission that it is tasked to. So in my view, it does not make sense to have specific different rules, although you can have different applications of the due regard rule across all three contexts. I do think that from what I have seen, the defense side is a little bit more willing to lean forward on their interpretations, a little bit more willing to kind of push the envelope in terms of finding definitions, finding norms of responsible behavior. The defense context has a lot at stake in terms of that concept of responsible behavior, both in terms of the value of their own assets and activities, but also in terms of being charged with protecting national security and security in space. If there is misperception and escalation, that is going to directly impact the day-to-day lives of those folks who are working those COD missions, not just for the United States, right, but for other states as well. And so they really have a strong interest in saying, we need to understand what responsible behavior looks like, so we know when certain behavior is something that we should be concerned about that might trigger an escalation versus something that we're just not understanding what's going on and there's not communication and we don't have any norms. So how do we know what's going on? Do we react or do we not? That's extra dangerous in the defense context. So I think that's maybe why you're seeing a little bit more willingness to invoke those terms or use that language in a defense context than in some of the other contexts.
All right, so the next question comes from Mr. Patrick Lynn. And you mentioned it a little bit in your discussion of those tenets of responsibility, right, that were issued by the Secretary of Defense. But in the SecDef tenets, what does professional manner mean kind of in that context of due regard, right? You mentioned that phrase had been added to that general kind of tenet of due regard. Do we have a clear definition, or what would you say is perhaps the meaning of that phrase?
I don't think we have a clear definition. I think it's really trying to demonstrate that there's a level of transparency and a level of, what's the word I'm looking for, predictability that would evince professional manner, right? But there is not a specific definition there provided by the SecDef. I have not seen any follow-on guidance. That's not to say that follow-on guidance won't come out or isn't in the works. It very well may be, I don't know. I think that would be helpful. I also think that in the context of the Secretary of Defense, professional in terms of the profession of arms, how we would interpret professional behavior when you're talking about the profession of arms is probably the intent, is most likely the intent of how we would apply that to those tenets of responsible behavior.
Great. The next question is from Ms. Helen Yu. And she says, first, thanks for the great presentation. So thank you. And could you expand on why states might not be willing to commit to using kind of these principles of due regard and the due regard tools provided both under the Outer Space Treaty, right, and under these other interpretations? Or in other words, what's holding states back from implementing these principles of due regard?
So I think there are a couple of different things. One is just the political context in international relations. If you say a state is acting without due regard or is acting with disregard, you are essentially accusing that state of a wrongful act, right, of a treaty violation. And that has significant potential international relations consequences. So that's part one. And then once you've caused that interpretation, okay, they're doing something that's wrongful. The next question is, are we willing to do anything to enforce that treaty provision? How are we going to respond to something that is not just irresponsible that we don't like, but something that we see as a violation of the treaty? Well, if you can't enforce it, if you don't think that the international community is going to be willing to come on board and try to take steps to induce state behavior with that provision, then you might be afraid of weakening the provision or weakening the Outer Space Treaty regime by saying, hey, the state's not following it, but now we can't do anything about it and they keep doing it. What does that mean for the future of this regime? So there's risk to the regime there if states are not willing to have a consistent response. Now, there are things that you can do, like not invite states to participate in international cooperative ventures. Many of those occur, for scientific exploration, right? Exclude other states from participation. There are diplomatic avenues that you can take to articulate that behavior is not in conformity, to kind of name and shame so that others are less willing to cooperate, or that companies might not want to do business in that state, or you might prohibit your companies from doing business as far as space activities in that state. And there's certainly sanctions and stronger forms that could take place there, but those are only going to be relevant if multiple states are on board. Most of the regime is on board. And so the international, the member states of the international space law regime. So there's risk, right, to the regime from using that language. Finally, states might be concerned that they're limiting their own freedom of action, right? So if I say, hey, you're not acting with due regard when you do this thing, that means I can't do that thing because I've just come out and said, I think that's a wrongful act. So now I can't do it, or I'm a hypocrite. So if you think you might want to do something and you've already called it out, that's going to limit your freedom of action in the future. Certainly states are sometimes willing to limit their freedom of action, right? The United States came right out and said, hey, unilaterally, we're going to say we're not carrying out these ASAT tests anymore. So that's a great opportunity where the United States, if they felt the the political risk, the international relations risk was worth it to use those terms in that context, right? Because we've already given up that freedom of action, even aside from the due regard principle. So that's an example there. And one thing I want to say that's relevant kind of overall to this presentation, what we're talking about here are the specific legal rules, right? We're not talking about the ethics. There's a difference between the ethics and the law, right? Here, we're just talking about how do we apply the law? What does the law allow and the law doesn't allow? Just because the law allows something, that doesn't mean it's ethical to do, right? You can make a choice that is legal but unethical. And so none of what I'm saying here in terms of what is or isn't allowed under the rule makes an ethical judgment, right, of whether that action is ethical or unethical, but rather just does the legal regime permit it or not. So that's something else that we do need to think about in that context, aside from just, okay, is it legal or illegal, but are our actions ethical or unethical? Are the states, other states acting within this regime, are their behaviors unethical or unprofessional? That's another way we can look at that word professional, because ethical obligations often come from a framework of professional obligations. And that's potentially a separate set of questions that may not completely overlap with the legal regime.
Final question for you, Dr. Harrington, comes from Rick Eng, and he asks, are there any examples of states referencing the due regard obligation in their national space legislation or kind of national regulations?
Absolutely. The one that pops right off the top of my head is the 2015 Act in the United States that enables commercial entities to undertake space resource extraction and use activities, American companies to do that. That talks about conformity with multiple of the outer space treaty provisions, including due regard. But there are plenty of other examples out there as well. And so putting that in your domestic legislation is another great way to help develop that state practice, because if you say in your legislation, we're doing this to conform with due regard, right, then you're helping to interpret and apply due regard. Now, one state doing it in a specific context certainly is not enough. You need to see consistent state practice, but that practice builds. The more practice there is, the more helpful that is, the more opportunity that gives us to interpret and apply the provision.
Ma'am, I would just like to thank you again so much for agreeing to kick off this academic year of our monthly space law webinars. Wonderful presentation, and thank you for sharing this information about due regard with us. I think it has been very, very valuable, and I think that the questions we've received today have definitely reflected the interest of our audience, right, in the topic. It's a very, very important one, certainly from the United States military's perspective, right, as well as just generally kind of in a national context and an international context as well. And so with that, ma'am, having seen no additional questions flowing into the chat or the Q&A, do you have any final comments?
No, thank you. I appreciate you all coming out to listen to this presentation. I hope it has created some food for thought and food for discussion as you continue to carry on, whether you're students at USAFA or scholars working in this field or just generally interested. If you want to discuss it further, please do feel free to reach out and make contact, because this really is my biggest research project. As I said, it comprises multiple pieces that I'm undertaking right now from a scholarship perspective. And so if you have comments you want to add, thoughts you want to add, discussion that can help me as I'm continuing to develop this project, I'm happy to have those conversations.